This is the second in the series of lectures on litigation. Let's start by looking at how the process of litigation begins. The paperwork to start a litigation case is called the pleadings. The filing document is filed by the plaintiff, the moving party. It's called a complaint. It sets forth who the parties are, the nature of the dispute, and the relief sought. The defendant files its answer, including its defenses. If it has a claim against the claimant, that is called the counterclaim. If there's more than one defendant and they have claims against each other, those are called cross-claims. This terminology is substantially similar to what you saw in arbitration, with the primary difference being complaint and demand. Demand is not really used in the court process. The big difference here is that the rules of the court, the rules of civil procedure, strictly govern the format and the timing surrounding all of the court pleadings. They are very strict, and complaints, answers, counterclaims, cross-claims can be thrown out if they do not meet the specific requirements of each court. You can go back to the websites cited in the earlier lection and look at actual court documents to see their degree of specificity. In arbitration, even where providers have forms, those forms are a preference. Most providers will accept more informal pleading documents and responsive documents. ADR providers and arbitrators also have a little more flexibility with granting extensions. In court, if an answer is not filed in a timely manner, the plaintiff may be able to move for a default judgment, which basically means that the plaintiff wins merely because the other side did not file its responsive documents in time. Now, that can usually be set aside, but obviously that adds to the time and the cost and potentially the contentiousness of the case. So the pleadings, their purpose is generally the same. The requirements in terms of form and timing are much more strict in court than they are in arbitration. Now let's look at the decision process and the decision maker in particular. Trials are either what's called a bench trial or a jury trial. In general, there's a constitutional right to a trial by jury. Parties can agree to waive that, though, and have what's called a bench trial. In a jury trial, the judge oversees the process and gives instructions to the jury about the law and how to apply the law to the facts. In a bench trial, the judge is the process overseer, but also the final decision maker. Now let's take a look at how decision makers are selected. Judges, remember, can be appointed or elected in a general election. Once they are within the court system, they are assigned to specific cases based on the court's rotation system. Juries are, as we are familiar with the term, a jury of our peers. Citizens are called up through the jurisdiction's jury process, and then once they are at the court docket that day goes through, and each judge assigned to each case meets with counsel, determines whether or not those parties are able to settle. If they are not and they are on the docket for trial, then a smaller group from the large jury pool is called up, and through a process called voir dire, which is the questioning of jurors, jurors are made part of the jury. It's usually a group of 6 or a group of 12, and usually 2 alternates, and that jury becomes the decision maker. Contrast that to arbitration, where the parties have a fair amount to almost exclusive control over who their arbitrator is. There's the listing process that you saw in the rules of the ADR providers, or the parties can directly agree upon whom they want to serve as arbitrator, or they can do sort of an in-between process, the party-appointed system, where one party selects one arbitrator, the other selects second arbitrator, and those two get together and select the third. So in a court system, you're going to have a judge who is a process expert and may have some subject matter expertise. The jury may or may not have members who have some subject matter expertise, but they usually don't have the training other than judicial instruction on how to apply that expertise to the facts at hand, and those biases can work in favor or against a party, or in some cases they may be completely neutral and they won't matter. Arbitrators have both process expertise and subject matter expertise. So there's substantial difference in the decision maker between arbitration and litigation. Now let's move on to the next phase of the process, which is the discovery phase. Discovery in arbitration and litigation is substantially similar. Interrogatories, deposition, document exchange, etc. The difference is accessibility to it. In arbitration, as you read about, primarily the parties rely on document exchange. In the more complex cases, the parties may agree or the arbitrator may determine that expanded discovery, usually in the form of depositions, is allowed. The difference in litigation is the parties have a right, because of the rules of evidence, to engage in more expanded discovery, and you frequently see depositions and interrogatories. Now, in both arbitration and litigation, there's what's called a pretrial conference or a preliminary hearing. In the two different procedures, these pretrial conferences are substantially similar in purpose. Counsel and the judge identify what is the necessary level of discovery needed for the parties to find out the information in order to prove or disprove the case. They set up a schedule, which usually includes status conferences, and additional status conferences can be used for either a judge or an arbitrator to resolve any disputes the parties are having about production of documents or scheduling of depositions. This is where arbitration and litigation are substantially similar. Both recognize the importance of discovery being available to the parties, but not overtaking the case, either in terms of time or cost. And courts are much more responsive to efficiency in discovery than in the past, but again, because the parties have a right to certain types of discovery that they do not have a right to in arbitration, the discovery process is usually longer and more intensive in court than it is in arbitration. Now, once the parties have discovered information and can prepare their cases, they move on to the trial phase of the case. I'm going to pause here for a moment and just give a reminder that whether it's arbitration or litigation, there are lots of off-ramps from the pleading stage all the way up to trial and even during the presentation of evidence, where the parties may settle their case either through direct negotiation or concurrent mediation, or oftentimes during the discovery phase, an arbitrator or a judge may suggest to the parties that if they had been in mediation, they try that again, or if they haven't been to mediation, it might be a good time to do it. What is usually another driver for the parties to go back to mediation or to start it at this point is the cost. And as they start receiving their discovery from the other side, they may start to see weaknesses in their cases and see that it is better at this point to try to settle than not. The reverse of that, of course, is true, that a party may find its case is stronger and wants to push through and have the judge or the jury, or in arbitration, the arbitrator, make the final decision. Now, the trial process is fairly standard and familiar to most people. It starts with counsel making an opening statement outlining what the case is about and what they expect to prove. The plaintiff puts on its case, the respondent puts on its case. There's an opportunity for each to rebut the other's case, and then counsel make closing arguments. Where there is a bench trial, the opening statements and the closing arguments might be substantially reduced or possibly even eliminated, because a judge, being a professional decision maker, does not need that level of review and reminder on either the facts or the law. But in jury cases, you're going to see opening statements and closing arguments. Once that is concluded, then the decision maker's process starts. And here again, we have a fairly substantial difference between the arbitration process and the litigation process. One of those differences is the role of precedent. A judge or a judge giving instructions on the law to the jury must follow precedent. And what precedent is the decision of prior courts on cases where the facts and the law are substantially similar. And this is looking at the appellate level decision, so where an appeals court has heard and decided a case with substantially similar facts to the case that is currently pending in this litigation. If there is a decision, then a court must follow its own state's case law. It doesn't have to follow the case law of other states, but it is often used as guidance. It doesn't have to follow federal court decisions on the same subject matter with substantially similar facts, but again, it can be used as guidance. The exception to that is if there is a Supreme Court decision that must be followed by all state courts. And some of the reasons that we use the precedent system in our jurisprudence system are predictability and conservation of judicial resources, so that courts are not continually retrying the same set of facts and coming up with different decisions. It is a lawyer's job to look at the case law and determine if there is appropriate case law that is on point with the case at hand, and to either find the case law that supports its position or the other party to find case law that refutes the position. It is also the lawyer's job to find exceptions, so that if there are 5 or 6 cases that are somewhat similar, but the facts of those cases can be distinguished from the facts of the case currently being tried, that is the lawyer's job to make those distinctions, to say, yes, there is precedent, but here is why we do not need to follow it. And again, the converse, the other party will say, no, those exceptions are not substantial, and we do need to follow it. Now, where case law develops over time and there are substantial exceptions, that is how precedent changes and keeps up with what is happening in the law, what is happening, for example, with technology, to make sure that case law is staying current and appropriate for the cases that come before courts. There is an argument that precedent shouldn't be followed, but currently that is our jurisprudence system. Now, arbitrators are not strictly bound to follow precedent. One of the other distinctions we have is burden of proof. And again, arbitrators are not strictly required to follow a burden of proof. Courts are. In civil cases, the burden of proof is usually what is called the preponderance of evidence standard. Now, this standard means that it is more likely than not that all of the evidence presented by the moving party is convincing. There is a higher standard called clear and convincing, and that is not quite the level that we're all familiar with from TV, beyond a reasonable doubt, but it is more than a preponderance of evidence standard. So again, juries and judges must look at the totality of the evidence presented and determine if it's preponderance of the evidence, if that's the standard, or if it is substantially more evidence than not, and apply that standard. Now, once deliberations are concluded, a verdict is rendered. Verdicts are automatically converted to judgment in court, and if a party does not voluntarily comply with the court's judgment, the prevailing party may pursue collection remedies such as seizure of property or a lien on wages. In arbitration, it is somewhat similar, although an arbitrator's award must first be converted to a judgment. It's not a retrial on the merits. It is a simple court proceeding, and then the prevailing party in arbitration has the same remedies for collection as if it had proceeded through litigation.